and freedom of speech conversation. The History Department's Equity, Inclusion, and Diversity Committee wants to give members of the VCU community a chance to engage in discussion about VCU's proposed campus expression and space utilization policy while it's still in public comment period. We hope that this event helps students, staff, and faculty better understand their rights. And we strongly encourage you to comment on this proposed policy before the deadline this Friday, the 28th. Joining us in this conversation is our guest speaker, Professor Zick. Professor Zick graduated summa cum laude from both Indiana University and the Georgetown Law Center. He received the Francis E. Lucy S.J. Award at Georgetown for graduating at the top of his class. He's done extensive work as an associate with firms in DC and Boston and as trial attorney with the Department of Justice's Federal Programs Branch. He joined the William & Mary faculty in 2008 and has won the Plumeria Award for Faculty Excellence 3 times since 2011 and received the McLaughlin Award for Exceptional Teaching in 2022. He is currently the John Marshall Professor of Government and Citizenship, which is one of the oldest professorships of constitutional law in the country. Professor Zick specializes in constitutional law as it pertains to the First Amendment, specifically free speech and press, and the Second and 14th Amendments. He's written a variety of books centering around free speech and civil liberties, with his most recent book titled Managed Dissent, The Law of Public Protest, talking about the law surrounding public protest and the ways in which restrictions on dissent are in great need of reform. We are so excited to have Professor Zick here to talk with us about the right to freedom of speech and expression on campus and how that relates to constitutional rights.
Thank you all. It's a pleasure to be here. I'm a Richmond resident, so I live not far from here, and I rode my bike over here. It's a beautiful day, so I'm so happy to be here. The introduction was terrific. Thank you so much for all of that. I have a long-time interest in public protest, free speech. Written 2 books on that subject. My first was called Speech Out of Doors, and my most recent is called Managed Dissent, The Law of Public Protest. My general perspective, just to put it up front, is I am a supporter of campus speech and campus activism, and I think both are valuable and venerable traditions that we should attempt to preserve. I've written a recent piece called New Threats to Campus Expression, in which I express some concerns about, in particular, what happened during and then after the recent protests on campus involving the Hamas-Israel conflict. I examined that paper both in the moment and after universities had a chance to think about it, what kinds of policies they adopted in the wake of those protests and that civil unrest on campus. So I'm going to speak sort of in general terms. I'm going to frame my comments around your proposed policy and talk about some things that are in it. I'm going to speak only for myself. I'm a lawyer, so I have to say these things, and not for my law school, certainly not for the Commonwealth. I'm not here to give legal advice. I'm going to talk about legal subjects. And I'm certainly not here to criticize the people who put effort into the VCU free expression policy, the proposal. I was the co-chair at my university of a similar committee that put together our policy and took a look at all of our free expression and facilities policies on the William & Mary campus. So I know how much work goes into coming up with a proposed policy. Let me talk about free speech or First Amendment on campus sort of in general terms for a few minutes. The First Amendment only applies to governments and governmental actors. Since this is a public university, the First Amendment applies here. Private universities can go their own way, although most of them adopt policies that track First Amendment protections and standards, and they support at least in their policy statements, free expression for students and faculty and the like. So some of the principles as they apply to campus in terms of the First Amendment are clear, but a lot of them aren't. And part of the reason for that is the Supreme Court, which has the final say on these matters, hasn't said very much about free speech and assembly on campus, which is kind of surprising. Given the long history of protest and assembly on campus. What the Supreme Court has said, it said mostly back in the 1950s and 1960s, when it addressed civil unrest during that period. And the things that it said were very supportive of free speech on campus and academic freedom and the like. So the court, for example, said in one of its opinions that the First Amendment should not apply with less force on a campus than it does off campus. It described the campus, the classrooms, and the rest of the facilities as something of a marketplace of ideas, which is a First Amendment concept that relates to using discourse and speech and counter speech to try and get at the truth. It has said or emphasized that the principal functions of universities are to produce and disseminate knowledge, and that we should protect free speech on campus primarily, although not exclusively for those reasons. And your policy contains those principles as well. It says right at the top in the policy statement and purpose, VCU supports and advocates for free expression, understanding the pivotal role open dialogue and exchange of ideas play in the pursuit of knowledge and innovation. Our commitment to fostering an environment conducive to civil discourse is rooted in the belief that academic excellence and societal progress are linked to the vibrant exercise of protected speech and other forms of expressive activity. So the policy, at least in words, supports the principles that the court has identified with respect to campuses in the First Amendment and free exchange of ideas in particular. I want to talk about the scope of speech. This is going to be sort of basic information, but I think I should add assembly here too, because the First Amendment protects the freedom of speech and it protects a right of peaceable assembly. And sometimes there's confusion about the scope of those protections. What do those words mean? In terms of speech, of course, the oral and written forms of communication are clearly covered by the First Amendment, as are things like chalking words on sidewalks, and your policy addresses chalking. Die-ins are a form of what's called expressive conduct. So even if you don't use any words, you are communicating in that context a message, and therefore your speech is contained within or within the scope of the First Amendment. Of course, peaceful forms of assembly, rallies, demonstrations, protests, parades, all of that is encompassed within the First Amendment's protection for speech and assembly, and so are things like peaceful vigils and the like. So quite a bit is encompassed within the First Amendment's terms that isn't written or other forms of traditional communication. The Supreme Court has identified, though, several categories of expression or communication that are not covered by the First Amendment. I want to spend a couple of minutes talking about those. They're mentioned in the policy as well. One is inciting others to engage in or commit imminent lawless action. A very difficult standard for the government to meet when it prosecutes under that standard. But the idea is you can't stand before a crowd and essentially intentionally incite it to do something like break into a building or burn it down. So incitement is not covered and can be punished. So can what are called true threats. These are serious expressions of an intent to cause physical harm to another person. And fighting words, these are the terms the court has used to describe these categories. Those are words, usually epithets or profanity that are delivered face to face that would cause a reasonable person to react violently to those words. Defamation, which involves communicating false statements of fact about a person that harm that person's reputation. And forms of persistent harassment. So either through words or conduct, persistently following, dogging, and harassing a person in the campus environment so that they cannot pursue their own educational opportunities. That's typically considered to be sort of one-on-one, and it has to be under legal standards persistent, but harassment is another category of speech that the court has found to be uncovered by the First Amendment. So those are limitations, again, recognized in the policy, and well established, even if they are sometimes hard to define and difficult to apply. There are forms of conduct that the courts have found to be unprotected. So things that you cannot do, claiming some First Amendment right to do them. Clearly, acts of violence, physical assault, for example, are not covered by the First Amendment. Vandalism, even if you want to convey your message that way, it has no First Amendment protection. Things like obstructing roads or sidewalks or on campuses, entryways to buildings. You cannot claim a First Amendment right to do those things. You can violate rules with respect to them as a matter of civil disobedience, which is sort of a moral claim that the law is unjust. But that claim comes with responsibility of being punished for engaging in that kind of conduct. So those are not forms of protected conduct either, nor is occupying a building, so taking over an administrative office, however you got in, however you entered, and staying there for all hours. None of those forms of conduct are protected by the First Amendment. So we have a few categories of communications that are uncovered, not within the scope of the First Amendment. We have some examples of conduct that you might see or might not see during public protests that don't have any First Amendment claim of protection attached to them. But that leaves a whole lot in terms of expression, in terms of expressive conduct and the like, that is protected on campuses, public universities, I'm speaking of here, under the First Amendment. So once you get beyond those limitations, right, the principal rule or standard that applies to governmental restrictions is one of content neutrality. I'm going to talk about that in just a few minutes. Thinking about the campus though first, including the classroom that we're in now, and the grounds outside, and the public areas of the campus, there is a doctrine called public forum that is used to determine where a person has a right, a First Amendment right to be, and determines as well what First Amendment standards apply to the speaker or assembly when they occupy that particular kind of place. So if you think about the open areas of campus, right, the campus, for example, those would probably be, I don't know that the court's ever addressed it, something that the public forum doctrine would call a traditional public forum, sort of quintessentially open to expression, where you would have the most robust First Amendment rights available to you. In the doctrine, these are places like public parks and plazas and streets and sidewalks, or the most open space you can think of on your campus would probably be something like a traditional public forum. But then you get into other spaces on campus, right? And those are going to be treated differently under the public forum doctrine. So classrooms obviously serve a special purpose, right? Education and educational discourse. They are not created, they do not function as forums for public expression. So you can't hold a protest in the middle of a class, for example. Those sorts of spaces are treated differently, and the government, in this case the university, is allowed to limit them to preserve them for their principal function, which is education. So too with administrative buildings. Those are not traditional public forums under the sort of terminology of the public forum doctrine, but they'd be something like what's called a limited public forum. They are limited to the sort of administrative work that is done in those places. And again, you don't have sort of a First Amendment right to claim public protests or engage in public protests there. Bulletin boards, that would be treated under the same public forum doctrine. So it's an expansive doctrine. Any place you can think of, you try to situate within this doctrine. And bulletin boards would be, again, places where the university may have opened them up to certain types of expression, maybe for certain purposes only, or maybe they've thrown them open to expression more generally, in which case they become what's called a designated public forum, and the rules of the public forum for that kind of forum would then apply. So I'll talk about content neutrality again in just a second. So there's the doctrine of public forum, which relates to place sort of a where question. Where do I have a right to protest on campus? And within those designated types of forums that I've been talking about, there are particular rules for First Amendment rights. So in a traditional public forum, for example, the government cannot restrict, punish, regulate speech based on its content, based on the idea that the speaker wants to convey, the message that they want to convey, the group's ideology, all of those sorts of things cannot be relied on by government unless they meet a very, very strict standard of judicial review. Talking about a court case, for example, they'd have to have a compelling reason to regulate speech, and the regulation they use would have to be narrowly tailored, almost like a presumption that a content-based rule would be unconstitutional. So that rule applies in traditional public forums. It applies in sort of designated public forums. It is a general First Amendment standard or principle that whatever else they can do, university administrators, state legislators, whoever's governing, cannot target a speaker or a group because of their viewpoint, because of their idea or their message, or as I said, their ideology. And that applies to, yes, individual speakers, but also groups that want to protest on campus. They cannot be told no if the reason for the no is the idea, the message, the viewpoint, the ideology. And student groups, recognized student groups and others cannot be treated differently because of the point of view or message or ideology that they adopt. So that's an important limitation on governmental restrictions on campus, but it leaves open a fair amount of regulatory authority for, I'm thinking of universities now. So what can they do in the context of a sort of content neutrality regime? Let's call that a default rule. Quite a bit that can be chilling to speech or even suppressive of speech, as long as it meets sort of the content neutrality principle. Universities can impose all manner of sort of time, place, and manner regulations. So this is another First Amendment doctrine. Time, place, and manner regulations can apply in any of the places I just mentioned, including the traditional open public forum. They can impose governments and universities requirements that you get a permit to speak. The permit cannot be granted or denied based on the content of what you want to say. But if it's based on objective considerations, the size perhaps of the group, or other things like that, if the standards are clear, you can require advance notice and a permit before you speak on campus. Now, those sorts of requirements, as I say, can be dangerous to free expression. Suppose an event occurs today and people want to gather in a public place on campus and protest. If I have a permit requirement that requires, let's say, 3 days advance notice, that's not going to be possible. I'm going to be in violation of that rule. So there should be some room in any permit scheme for spontaneous demonstrations. Think of the murder of George Floyd, for example, the protest that happened instantly after that, almost instantly, and spread across the country. Permit schemes can get in the way of spontaneous demonstrations. Fees, likewise, can be set at a level that suppresses protest and activism on campus. Most students can't afford to pay a fee, sizable one anyway. Most groups on campus probably can't either. There's a fee schedule associated with your policy. So there's a recognition that fees can be dangerous in that sense, but there are fees nonetheless. So if there's a requirement, then the fee has to be paid. The Supreme Court has said virtually nothing about the requirement of fees, even though it's become a significant obstacle to protest in recent years. Some of the fees for protesting in DC and other metropolitan centers have reached into the tens of thousands of dollars. And unless you have an avenue there for people who can't afford the fee to be waived in anyway, that can be suppressive of speech. The court upheld a fee requirement, the Supreme Court, back in the 1930s, That's the last time it addressed it, and the fee in that case was $300. And it was a flat fee. So it hasn't said anything since then, but governments, regulators have charged fees nonetheless, and there are questions about how much you can charge, how closely it has to be related to security or cleanup costs or whatever the government's justification might be. So that's an open area and one of concern. There are a whole host of content neutral regulations you see in almost every university policy that I've ever looked at, including my own at William and Mary. So these are regulations that, again, are not based on the content of the speech, neither its subject matter nor its viewpoint. It address other matters, right? So if you think about a rule that says you can't have any demonstrations or any activity during exams, a sort of time restriction, right? A period in which, because of the need for tranquility inside the classrooms where exams are taking place, you simply can't have any, I'm saying demonstration, but however you define it. So that obviously is content neutral, but it's also a ban on a form of speech, right? You can't have any protest or any sort of assembly or any speech that disturbs during exam periods. Another common one, a ban on activity within, let's say, X feet of a classroom. So while classrooms are in session, or maybe even when they're not, there's just a set rule. Whatever your group is, whatever your interest is, or your viewpoint, you simply cannot protest or engage in this kind of activity within X feet of classrooms. Now, if X is 1,000, right? I may argue that the breadth of that ripens into an unconstitutional prohibition. It has to be tailored to the interests that the university is trying to serve, right? So 50 feet or 100 feet, but 1,000 feet displaces speakers more than would be necessary. So all of that's to say, I'm not saying these are necessarily constitutional. They fit the content neutral time, place, and manner form, but they are still subject to some review. Same with limits on where large demonstrations can happen. There are only a few places on campus, on this campus and mine, where you can actually host large demonstrations. I'm just leaving that vague. But if you're thinking of hundreds or even thousands of people, the university could say, well, we're going to allow large demonstrations, but we're going to restrict where you can hold them for public safety reasons or public order reasons or tranquility reasons or what have you. And restrictions, these are both in your policy, restrictions on sound amplification, sort of manner restriction, or chalking. So these are ways of speaking or ways of amplifying speech that if they're dealt with in a content neutral way are probably constitutional, probably don't violate the First Amendment. But again, I want to be careful with that because it depends on how they're written. It depends on just how broadly they restrict speech. And one of the concerns that I've expressed and what I've noticed in campus expression policies, particularly since the Israel-Hamas conflict has died a little bit, at least on campuses, is the accumulative effect of these sorts of restrictions. So it's one thing to have sort of a framework for public order on campus and safety on campus. It is quite another to have a policy that is so minute in detail that students run the risk of violating one rule or another almost anywhere they go, or almost in terms of anything they do. So these sorts of regulations are treated as less dangerous to First Amendment concerns. I don't think that's quite right, and I've written as much. I think even though they're content neutral, they can have a chilling effect on speech on campus, and they can be every bit as problematic as some of the content-based regulations that courts treat as fundamentally invalid. There are a couple of things in your policy I want to raise because they've been sort of in the news recently in general. So that's the conclusion, sort of the general information I want to convey. There are two things I think on page 7. One of them deals with encampments. So lots of universities now have, as your proposed policy does, a ban on encampments. Prior to the recent campus protests, most universities didn't have one. Maybe they didn't think they needed one. Maybe it didn't occur to them that students would engage in this sort of expressive behavior. And I think it is expressive. It's a form of expressive conduct. So I think it's speech and largely peaceable assembly what's going on there. But in terms of its regulation or even its prohibition, there's actually a Supreme Court case on point. It's called Clark versus CCNB, decided in 1984. And it's a case involving advocates for the unhoused who wanted to camp in Lafayette Park and other places in the capital city, DC, in order to express to lawmakers just how difficult it was to be unhoused. And the Supreme Court upheld in that case a National Park Service regulation that, very similar to the policy you have here, banned encampments, forms of camping, overnight sleeping, and what have you. And it did so in part because it deferred to the government's interest in protecting the lawn in DC, right? So free speech balanced against sort of beauty of the lawn there. This rationale has been used in Sheep's Meadow. If you've ever been to Central Park in New York City, it was used by Mayor Bloomberg effectively to prevent political demonstrators from gathering, too many of them anyway, in a place where New York City had spent lots and lots of money to make the grass really pretty. So that case, I think, probably justifies the bans that universities have passed if they are content neutral. And most of them are written that way. But as you probably can tell, I'm a little bit skeptical because the bans follow very closely on the use of this kind of expressive conduct by students and other activists. The courts won't treat that as content-based, even if the regulation follows very closely on the activity that's being regulated. And the common sense principle there is if we have that as a rule, then governments couldn't respond in the moment or shortly thereafter to things that happened that they didn't anticipate. So it's likely that these sorts of encampment bans, if they go to court, if they're challenged in court, would probably be constitutional based on Clark versus CCNB. The last thing I want to talk about is the activity sometimes called shouting down or interfering with a speech by a speaker, let's say, who's been invited to campus. This is a still from, I forget the college now, but it was Charles Murray, a very controversial author, and students there, Middlebury College, I think it was, not only came and did these things that you see here, but actually stood up, shouted, and at some point engaged in physical altercation with the faculty member who hosted Murray and with Murray himself. So your policy bans some of this sort of behavior. It says a person cannot obstruct or disrupt or attempt by physical force to cancel or discontinue speech by any speaker or the observation of speech by any person intending to use or to hear a speaker. Sort of a long-winded way of saying, if somebody is scheduled to speak, say in this room at a certain time, you can't show up and prevent them from saying what they came to say. Now, that doesn't mean that you can't come to the room if it's open to an audience and you're part of that audience and ask questions of the speaker that the speaker doesn't like, make them uncomfortable. It doesn't mean you can't engage in exactly what these students are doing, which is holding up signs. It doesn't mean you cannot turn your back. It doesn't mean you can't wear things on your shirt or other articles of clothing that indicate your displeasure or disagreement. It means only that you cannot, and that it's inconsistent with free speech principles, to essentially just shout a person down and ensure that whatever they have to say cannot be said. Now, the policies are hard to write. So what's the difference between shouting down and counter speech? What if I'm making muffled noises or kind of laughing or cackling at the speaker from the back row? The policies are difficult for that reason. So under your policy, what does it mean to obstruct or disrupt a speaker or event? If any of you were doing any of these things, I guarantee you I'd be distracted, maybe not disrupted, maybe not obstructed, but it depends on what you're holding, what's on your side, so what's on your clothes. So I raise that because in part it's become such a sort of hot button topic, a hot topic on campuses. There's often more heat than light thrown on it. It doesn't happen, in my view, as often as the media would have one believe. It happens in my realm, in the law school realm, mostly at so-called elite institutions like Stanford, Harvard, and Yale, and Columbia. But when people ask me about William and Mary, I said nothing of this sort has happened. In fact, my students have come to me in advance of speakers they disagree with and said, what can I do to register my dissent and my discontent? Now, those are law students, right? So they're acculturated to law and legal rules and legal principles, and they're scared to death of being disciplined for anything. So I think it is different for younger students. They may not know the limits of what they can do. Part of the reason they may not know is because it's not clear in the policies they have. Or maybe whether or not it's clear, they're going to engage in this behavior. And as I said, as a matter of moral principle or civil disobedience, just take the consequences of the rule violation. But these sorts of activities can result in discipline, up to and including expulsion. And universities are very much keen to write this sort of limitation into their policies. And your policy now contains, I don't know if it used to, one of these limitations. So I'll stop there. I'd be happy to take specific questions or just questions about the general things I've said about the First Amendment or disagreement with anything I've said. The floor is open, I assume, yeah?
Thank you, Professor Zick. So you talk about the fees that are set for protesting. Is there any transparency required in the fees, like when those fees are set, like what they go to, or like limit, or can the fees kind of just be set without having that transparency?
Yeah, it's a great question. Lower courts have issued opinions on fees. The Supreme Court hasn't, as I said, since the Great Depression, essentially, or shortly thereafter. And the objection that courts have entertained, and some of them have actually accepted as valid, are that the fees are not, as you say, transparent. It's not clear what I'm being charged for. If you're charging me for security, I need to see that up front and to have some sense of why the security is X versus Y. Same thing for cleanup costs and those sorts of things. So whether it's a requirement or not is difficult to say, but you can get yourself into trouble if you aren't transparent about that. And I didn't look at your fee schedule, so I didn't go into the details there. But if it doesn't, and it just says a flat fee of some kind, then it's problematic to do that. My personal view is it's problematic to charge any fees at all to speakers, particularly in the context of a university. Some of the groups and advocacy organizations that protest in DC, sort of repeat players, they can raise money. I still think it's burdensome and potentially chilling. If you have to bring your own porta potties, which some jurisdictions now require, if you have to pay overtime police fees, at some point it means there are groups that are just going to say, forget it, I don't want to do it. But on a university campus, it's very problematic. And you have to be careful too, I didn't mention this, so that your fees are not variable. In other words, they can't be based on some projection or prediction by the university as to how much controversy your speech is going to cause. That's a form of viewpoint discrimination. That's a form of discretion that governments are not permitted to have. And so you've got to be careful with that one as well. Fees have been a huge issue in the campus protest environment since at least the Berkeley a Free Speech Week fiasco out in California, it cost Berkeley a couple of $1 million in security and other fees to sort of police those intended speakers, some of the provocateurs that people had invited to campus. Where is that money going to come from? The university would like the state to pay for it. The state doesn't want to pay for it. There is no clear answer to whether, whether and how much you can sort of burden speech by charging fees. I think it's a really important question. It needs more judicial attention for sure. Yeah.
Other questions? So as you know, we are in the middle of a city.
Yes.
And I don't know how much you read about them more. I don't know what to count as the most recent protest. I'm thinking of the ones last spring. And there were state officials, as I understand it, involved in calling police into campus. So could you talk a little bit about the relationship between kind of city and campus,
Yeah.
and state and city police and that kind of thing?
Yeah, as a general matter, right, I didn't mention this in my remarks, but it is in your policy. There are a number of places where members of the community are treated as sort of, they're non-community members, right? So they can be treated differently in terms of access to campus.
You're talking about like not students?
Yeah, I'm talking about just people like myself who might want to come and be on campus for some purpose. That's okay. Under the First Amendment, you can restrict access and prefer students and faculty and staff for those sorts of things. I think it's a mistake to overly restrict access by the public because universities, especially like this one, are sort of the heart of a city, right? There's a relationship between the general public and the university. So I think that's a mistake. I understand why. You might not want so-called provocateurs or, sort of outside agents. That was a big issue with the Columbia protests. There was a lot of speculation that most of that wasn't student-driven, but rather driven by professional activists or Antifa or whatever it was. Calling in the police became an issue at Columbia as well, because for the longest time, Columbia had not done that as a matter of policy. And the reasons for that became pretty obvious pretty quickly. Because when you call law enforcement to sort of quell unrest, what often happens is unrest is not quelled, it goes up. That the confrontation becomes with the police and they're not actually solving the problem, which isn't to say that you shouldn't have any law enforcement presence or they shouldn't police vandalism or violence or any of that stuff. But just to give an example, I'm not on your alert system, VCU's alert system, I'm on my own, but some of my neighbors are. And they sent me an alert during one of these protests that you just referred to in the spring. And it was something to the effect of danger, stay indoors. I mean, I live 2 miles from here, so I got on my bike and came down here to find out what in the world's going on. Like it's field research for me, and I did this for the Black Lives Matter protests as well, just to see from my own eyes, or with my own eyes, what was going on. And it was nothing to me. It was like once you put police in the mix, yeah, okay, I can see a conflict brewing. But if it was just 30 or 50 students, I think it was near the library, gathered to protest, why are we treating that like it's some kind of emergency? And I think we've reached a point, we certainly reached it, I think, during the Black Lives Matter protest, where a lot of people just see a gathering of people who want to protest as an incipient riot. That it's unlawful. I had a lot of neighbors come to me and say, well, why should people be allowed to protest at night? Why can they protest where people live? Where would you like them to protest? Or because they want to reach an audience. And the sort of premise behind all of that was protest is itself a form of lawlessness or a disorder that we shouldn't tolerate. So I had lots of those debates, oftentimes with people who didn't know what I do for a living. So it was interesting to hear people's perceptions, but of course you can protest in public places, and of course you can protest even in residential neighborhoods and sidewalks. And to me, that's a good thing. That's a positive thing. And I didn't feel threatened, as a lot of people seem to. So I don't know if that answered the initial question, but
Yeah, but just because you mentioned the thing about failure to follow an instruction from University Police.
Yes.
Which is in our policy, but then I
Yes.
think in that situation you described, there are students and faculty members that were on campus that report what you reported.
yeah,
But there was also this kind of, sort of question of, I mean, there's different levels of, right, policy and law applying.
absolutely, yeah.
All
And
at
you've
the
got,
same time.
and you've got
I'm
campus
very
police,
Yeah.
campus police, state police. I don't know about, other forms of security, but, as soon as the protests, last spring, came about, there were calls for the National Guard. Before any student had burned anything or broken anything really, and that did happen, there were students who did that. That's an escalation, in my view, not a helpful one. It does not quell unrest. It exacerbates a situation that's already tense. Which is not to say you should just let people do whatever they want. I've gone through the restrictions on what you can and can't do. But, order is what university administrators want. That is their primary objective. And protest is supposed to be disruptive. If it doesn't disrupt anything, then the chances that people are gonna listen to it or be affected by it, are pretty minimal. So people don't always agree with this, but Justice Douglas on the court once said, campuses, should have a spirit of rebellion. I think that scares people. It shouldn't. I mean, we had campus protests during the civil rights era, the Vietnam era, apartheid. This is one of the places where conscience is, right? I don't think we should be punishing and discouraging students as much as we do from engaging in protest and other expressive activity. Because if we do, when they leave here, they'll be less inclined to engage in that behavior elsewhere. So I know there's a stark divide there. There are people who say that things got out of control. We just have different, I think, notions of what out of control is. I don't think this picture is out of control. I don't think this one is either. Although I can see why universities don't want students living outside. It could be unsafe for them. But to send in armed law enforcement, pepper spray, at my alma mater, Indiana University, there was not this big.
It's mine too.
Okay, yeah, so it wasn't this big, but there was an encampment, and they put snipers on the tops of buildings. They didn't shoot anybody, but my question is, why do you need snipers at all? Right, it's just like the show of force is meant to deter students from engaging in even peaceful, if unlawful in the sense that they're violating some rule, protests. So I have written a lot about escalation and protest policing, as have others, for many decades, some of them. And it always shocks me how little progress has been made on that front. And all of the mistakes and all of the problems with protest policing were on full display during the Black Lives Matter protests, when police engaged in all kinds of aggressive behavior toward people who were not resisting them. New York's Attorney General actually sued the New York City Police Department because they violated so many people's rights. So we've got to find some balance here. I realize that, but I think we've tipped too far in what my book refers to as managed dissent. So that's the reason for that title.
Other questions or comments about, yeah?
You said that it could restrict like X amount of feet within the space of classrooms. Could that stretch into like public spaces for public demonstrations, like if they wanted to restrict speech in Monroe Park?
I assume that Monroe Park is not under the university's jurisdiction, or am I wrong about that? It is.
Technically.
The cities, yeah.
But it isn't within 1,000 feet
I
of
see.
the campus.
Yeah, well, then you are outside your own jurisdiction, but my problem with 1,000 feet is probably that it's just overly broad in terms of whatever you're trying to accomplish. maybe you could do something like 100 feet and then you restrict sound amplification. I mean, it's obvious you don't want to disturb students who are trying to take exams, or I think most people would say, yeah, of course. How you do that, I think, is the sort of First Amendment question here. And part of the First Amendment standard requires what's called tailoring. So a fit between your objective, you, the university, and the measure, the means that you've adopted to address it. So I think 1,000 feet is going to be problematic for the reasons you see. It's going to push you not only so far away, it may push you into other spaces the university doesn't have jurisdiction over. When they're inartfully written, they can push you into the middle of the street, which is obviously not safe. There were protests, I'm thinking of this example because of your question, involving the Westboro Baptist Church that protested military funerals, became infamous for doing that. Right away, almost every jurisdiction, state, local, and federal, had an anti-protest at funerals law. Some of them were written so that the group in question, the Westboro Baptist Church, was pushed into the town dump. Right, so that, you can use those sorts of so-called time, place, and manner restrictions in a way that is, dangerous if you're trying to protect safety, or you're doing the opposite, and suppressive of speech. So yeah, gotta be careful with those.
Other comments or questions?
You've, laid out all of the kind of the things that are not protected by the First Amendment. And my question is, with the increased restrictions on the chalking policy, I mean, what is the justification for that?
Tell me a little bit more. So I read it, but it's been a minute since I looked at the policy. It says you can chalk in certain areas of campus, I assume.
Yeah, but you can chalk on the compass now, and you used to be able to.
Yeah.
Can't chalk under, I think, archways or doorways and things like that.
Yeah.
In my opinion, my uneducated opinion, these seem like arbitrary restrictions.
Yeah, I assume that they are principally aesthetic regulations, which sounds silly, maybe ridiculous when you're talking about fundamental right like free speech. Having said that, the CCNV case, which I mentioned earlier, that was the justification for upholding the ban on overnight camping in DC. The Supreme Court has recognized aesthetics or beauty as a significant governmental interest, which is what's required if the rule is content neutral. So yeah, I think those are problematic. The university can probably do that if, as long as it's doing it in a content neutral way. In other words, it doesn't matter who wants to chalk there, you just can't. But again, having said that, when I say something's a time, place, and manner requirement, doesn't mean it's outside the First Amendment's purview. It means I do want to know what is the justification for that, and how tailored is your rule to that justification, right? So when we dealt with this at my school, we didn't want people chalking on buildings, right? Statues, those sorts of things, but made lots of other things that were, on the ground, available for that sort of thing. It can be removed eventually, as your policy, I think, says, by people who sort of clean up the campus. But it offered lots of opportunities for that. And this seems to offer fewer, and I think that is troubling. But I'm not prepared to say it's unconstitutional, right? So I think aesthetics would be the justification. I can't think of another one. We just don't want a campus that looks all messy with all this like writing on the sidewalks and defacing the compass and all that stuff. So, yeah.
Did you get a chance to look at the interim concealment of identity policy around masking?
I looked at it, but I don't remember exactly what it says.
Well, I don't know if you have any, and maybe since you haven't looked at it.
Yes, that's okay.
Any individual who is present on university property or attending a university event and is wearing a mask, a hood, or other covering whereby a substantial portion of the face is hidden or covered to conceal the identity of the wearer must present an identification document.
Yes.
So I wonder how much, if you could just speak generally about how policies about masking interact with policies about campus expression?
Yeah, so this is an issue that's divided courts. The Supreme Court again hasn't said anything about it, but lower courts have sometimes invalidated those anti-masking laws and sometimes they've upheld them. And there's just a disagreement right now about whether they are constitutional or not. It's hard to write one that doesn't encompass things like, wearing a mask for health reasons, for example. Or wearing it as part of a costume or as part of religious garb. So they're difficult to write. That one sounds like it's just sort of a ban, right? Or it's not a ban, it's that I can ask you for ID.
Right.
So I guess they defend it as less than a ban, because it just opens you up to being, asked for your identification. Whether you can just ban people from wearing masks who aren't campus community members is an interesting question. I'd want to know the reason for it. I guess the reason is security and safety. The assumption is if you're wearing a mask, you're trying to hide your identity and engage in criminal activity. But I'm not sure that's that's a principle or premise that I'd be willing to accept. So sometimes mask wearers have argued what they're doing is expressive. I'm wearing a mask to express something. And other times, they're not making that claim. And I think courts have had a hard time with this because governments have offered different justifications for why they want to do it. So that's a common reaction to the protests last spring as well, because there were people wearing face coverings and so forth. So not clear to me whether or not that would survive or not. Yes.
I have a question. I think in many of these encampments, I think that was the case here at DCU too. The students have posed some demands of disclosure and investment, but the university had not responded to those demands. And in fact, I don't know if DCU ever responded to those demands, right? So I think I'm not a lawyer. I'm a history professor, but as an educator, I think that when students pose a question or a request, I have a responsibility to respond to their questions and requests.
Yeah.
And the university, as far as I know, hasn't done so. So, how does that relate to freedom of speech, right? Asking a question or presenting a request or a demand, right? And that timeliness, right? I think in this case, the university seems to have been relatively quick in setting a policy, but certainly not timely in responding to the questions of the students, right? And I think I don't know if the law talks about this, but as part of our educational responsibility, we are here to answer questions, right? So what are your thoughts about this as a faculty member?
Yeah, so part of what I wrote about in the piece that's coming out soon and called New Threats to Campus Protests was the sort of in the moment response that universities had to the encampments and to the protests, right? So how should you respond to that? And I was focused on university administrators, never mind the noise that's coming from DC and state officials and politicians. And too many universities, I think, responded immediately with force, or at least the threat of force, rather than what you're suggesting, which is dialogue. If your policy in its first 3 lines says we are committed to the pivotal role of open dialogue and the exchange of ideas and the pursuit of knowledge and innovation, then it strikes me that you ought to do that with respect to students who are making whether they're demands or complaints or whatever it is, find out what they're bothered by and respond to it in some way. If the answer is no, then the answer is no. But they should have a hearing of some kind. I think that's more consistent with free speech principles than what was done on most campuses. It's not required, right? There's nothing in the First Amendment that says universities have to listen to their students. But most of their policies are written in a way that suggests they would, or they should, and I think they ought to. And, people who administer, university provosts and presidents, who I've talked to at different events, say things that, lead me to say, well, it's a complicated issue because some of them did stay their hand. And they waited and things got worse, right? But very few of them did what you just suggested, which is to say, open a dialogue or have some kind of forum to address these concerns. It was almost instantaneously conflict. And there has to be a winner in conflict. The students have to leave, and then they have to be punished. Some of them expelled, some of them thrown off campus and treated as trespassers. That's where they live. So, and some of them denied their degrees and access to their graduation ceremony. So I think the punitive was driven, in part by the context at the time. So university presidents were being grilled by members of Congress. Some of them lost their positions, tried to resign them because of that. And there's this loud demand for teaching these kids a lesson. And I think too many universities sort of caved into that at the very beginning. And I think that was an unfortunate thing. And then on the back end, sort of use their summer break, as I've said, to develop policies to make sure that there are stricter rules, stricter than in your policy in some cases, right? There are some that require days of advance notice before you can have an event on campus, and they're enforcing these rules against students who are tabling in the wrong place. And if the students don't move, then they're subject to some kind of disciplinary action. So I think it's a moment that could have been handled better. It's easy for me to say that because I'm a faculty member who teaches the stuff. I don't have to administer a university campus, so I recognize that. But I think it was a lost opportunity.
Last question from anybody?
If I might, I think in recent years there has been a tendency to view students as customers or consumers, right? I mean, I come from Latin America where most public universities are free. Here students pay for their public university education.
Yeah.
So it seems contradictory to me that customers or consumers would be dealt with through force, right? What are your thoughts about this, right? Because these students were dealt with violence on ECU campus are paying for that education, right? Whether they took a loan or their parents are putting up the money, right? So what are your thoughts about this?
Yeah, there's sort of a weird disconnect when you, for example, you call students trespassers on a campus, where they're being educated and they're paying, as you say, to be educated. There have to be some rules of order, sort of Robert's rules of order that apply in public spaces. Everybody, I think, gets that. But that got a lot of attention, that notion that you're calling students trespassers or you're expelling them from their homes because maybe they didn't disband quickly enough when you told them they had to. And over 3,000 students and other activists were arrested during the period when these protests were really vibrant. That's a lot of arrests. You have to go back to sort of the Vietnam era to find anything remotely comparable. And during that era, there was a lot more violence and vandalism and unrest. So I don't know. I don't like all aspects of the consumer, as a faculty member. But in this context, I agree with you. There's a discord here in terms of how students are being perceived or treated. And it goes back to your earlier question about dialogue and being open with them. Maybe some of them aren't open to reason, but that doesn't make them any different from any other class of people in the United States. And I just don't see any reason to treat them differently on that score, or to sort of, this has become such a worn term, a snowflake, right? That you just can't handle being told no or that sort of thing. Or in this context, the other thing that I was concerned about was pretending that all of this is a function of outside agitation. That none of the students believe this at all. They don't have a cause here. They're being encouraged. They're being trained by professional activists. And there were people who were arrested who were not community members at Columbia and so forth. But it wasn't as many as people were pretending. So, yeah, I agree with you, the premise of your question. Not only because of the sort of money they pay, but because what we're trying, I think we should be trying to teach people. This was a teaching moment to some degree that I think, in large part, many people failed.
Thank you so much, Professor,
You're
for your
welcome,
time here
yes.
today.
Thank you,
Thank you to all
everybody.
of you for joining us this afternoon. We really appreciate you taking the time out of your day to listen. Please do review the public comment section on the policy use or the facility use policy that is open until Friday. And all those comments should be, we hope, read by the administration and taken into consideration before the policy is implemented in the future. So